Okay, we have some time for questioning. Does anyone, first from the audience, anybody want to raise a question?
It seems to me in the state systems that the bulk of the criminal defendants are poor and disadvantaged, and yet the laws under which they're prosecuted are pretty clear and have usually a strong mens rea. At the federal level, it seems to me the bulk of the defendants and the targeted people are the more advantageous people in our society, and yet the laws that are used to go after them are usually very vague and give the government a very broad brush, if you will. And I'm just wondering, in a democracy, how that happens.
Well, that's a very good question. Yeah, I think that goes to Alice, right? She's the apologist for.
Well, the Department of Justice doesn't write the laws.
Oh,
It's yeah, they do sometimes. That's true.
Sometimes.
You know, I think that there are some statutes that are a little bit broader. I wouldn't want to overstate it. There's a lot of clarity in the federal criminal rules and the federal criminal law as well. And we can talk about the differences between the knowledge standard or the willfulness standard, I think that somebody talked about earlier. And what does that mean? A lot of that has been interpreted by courts, and sometimes it's unclear. But I think that people do their best to prosecute within the bounds of the law and what the statutes say. I mean, it's the let's not forget. I mean, these statutes are written. It's the prosecutor's responsibility, and they are held accountable for doing their job and enforcing the law. That's what they are doing, and that is, that's their job. And if they didn't do it, they would be penalized.
Well, I would just comment on that, because in this whole area of valum regulatum, you have 3 levels of enforcement in the regulatory arena. You have administrative, you have civil, and you have criminal. And the Department of Justice manual for U.S. attorneys specifically says that U.S. attorneys should consider non-criminal alternative remedies. And I think that part of the equation is not being looked at least in the regulatory area regarding EPA, OSHA, and even in some of these other fraud-type cases, which may be more civil than criminal.
I'm not sure.
I actually said that during my talk, and I actually agree with that. That 9th factor in the corporate charging, which is alternative civil remedies, should be focused on a lot more in the discussions.
It should be. Unfortunately, the manual says that the prosecutor may consider this, whereas other provisions in they said that they should consider these various factors. So one of our things is to tell the Department of Justice to elevate the permissive may to the more hortatory should, or maybe shall, but nevertheless, it's all down to prosecutor's discretion.
I don't think either one of you has answered the question. I think the question was, how is it just, right, that some people are prosecuted under sort of fuzzy-headed statutes and fuzzy-headed concepts, and a different class of people are prosecuted under clear statement statutes. That's what I took to be the question.
I'll make one observation.
And especially they're prosecuted based on political pressure, which both Roscoe and Alice conceded to be actually what prosecutors do, which I think is certainly candid, but it should be disturbing that they base it on last week's headlines, just like the Congress people.
No, I just want to clarify. I didn't say that. I said that this is the framework that's going on, but I never said that they were making their. No, he said pressure. I never said pressure. And just to be clear, because this is a point I feel very strongly about, I do not think that prosecutors make their decision based on political pressure, and I do not think that the statements on the Hill are impacting the decisions that prosecutors make every day about which cases to bring, and I never experienced that in my time at the Department of Justice.
Let me just say, though, that since I haven't spoken on this point, may be true in the federal government, but if you're dealing with attorneys general, they are, I submit, incredibly motivated by political considerations. Just look at AIG and what Blumenthal is doing in Connecticut and Cuomo's doing in New York and the other 18 AGs who are issuing subpoenas, putting names in the paper, and satisfying the bloodlust. So DOJ may be perfect, but we are dealing with a much broader problem than just DOJ.
Well, and I think there's an additional point to this, and I think it's particularly a problem in the federal system, where the prosecutors are theoretically apolitical, which is where's the accountability? I mean, how do you assure the public that in fact these things take place? I direct that to either Alice or Roscoe because it's largely in secret. The whole thing is sort of cloaked in secrecy. And I think that naturally raises the question, doesn't power corrupt? And the less accountable it is, the worse it gets?
Well, I mean, one thing about the system is that, power, I think, to some extent corrupts anybody to some extent, but but they change. I mean, our system is one, and that's one of the reasons I think it's a good system, is that one day you're in power, one day, and the next day you're out. It's just the way it works. I mean, the longest you are probably going to stay in any one of these federal offices is 8 years. And it may seem like a long time, but I think in the scheme of things, it's not.
But Roscoe, aren't you seeing more career
Yeah, that's what I was going to raise.
now?
Hasn't there been a change over time? That used to be about 25-75, career 25, temporary 70. Now it's the other way around, isn't it?
I think
AUSA.
I think that's right. I mean,
I'm not talking about you guys.
No, but I know Washington. I mean, and I'm sure it's probably as you move away from Washington, as the jobs become a little more lucrative, depending on where you are, you'll find more and more career prosecutors. But don't misunderstand. When a U.S. attorney walks into a U.S. attorney's office, he or she's going to tell you, I'm in charge, and this is the way you're going to do things. And it's not that I disagree with Alice, and I really don't. But I think that there is, when you're talking about the president making a statement, it's not like we don't listen. And when you're talking about a senator making a statement, I mean, Alice knows this. I mean, all of the U.S. attorneys at one point were dragged up in front of the Judiciary Committee to talk about something. And you kind of understand what your marching orders are going in. And when you go home, you're going to make sure that the people under you do those things. Because if I'm in the U.S. Attorney's office in D.C., and I think there's a white-collar task force, and they're doing cases, and I'm losing bodies because of that, you want to know something? I'm probably going to start doing those cases. Because I don't want my people up in Delaware. And I don't want to start losing positions to Sacramento, and I don't want to start losing positions to Houston. And that's just the reality. Not everything you may agree with, but that's basically how you're measured. And it's not so much that a line prosecutor is sitting there going, oh, President Obama says to do this. But the effect, without a doubt, is not lost on any given office. And quite frankly, the bigger the office, the bigger the effect, because that's where the cases are. The guys in the Southern District of New York understand what's going on in Washington, and I'm sorry, I just think they react to it. And the people, when I was in the D.C. office, understood what was going on, mainly because I would bring them in, and I'd say, guys, this is what's going on. I'm not losing any more cases to the Eastern District of Virginia. This is how we're going to do things. And look, that to me, that was just the reality, and it's a political reality.
Okay, this lady up here is next, I believe.
Do you suppose that there might be a difference in the discovery between state system and the federal system that brings about a little more transparency and a little more preparation in prosecutorial cases in states in which they have liberal discovery? In other words, if a prosecutor is driven, it doesn't matter where you put them, they are going to be very thorough in their preparation. But human nature being what it is, do you suppose that some prosecutors may prepare more thoroughly, knowing that they are dealing with liberal discovery, and perhaps not so thoroughly in bringing charges in a system in which, under the federal system, there is very little transparency and not very liberal discovery?
I think the federal prosecutors can comment, right?
I'll take a crack at this. I think when you start in the federal system and you're talking about actually handling a case, a lot of times the lack of transparency, it's a mutual decision. Corporations don't want their name out there. I'm just going to tell you that. They just don't. They don't want it out there and that they settled something. They don't want it out there that they're under a deferred prosecution agreement. If they could, they will pay whatever penalty that it takes, but they don't want their name out there, especially publicly traded companies. They just don't. It hurts them. And it could be in a benign way. It could be that you had problems in there and you're helping, and you did nothing wrong. It hurts. And so they don't want them out there. So the lack of transparency, it's hurtful to the public. But I think that from a prosecutor standpoint, at least when I was a line prosecutor, and somebody said it, and I actually agree. Sometimes I just want the thing done. I really, the people who need to praise me will know. The U.S. Attorney will know when I was a line prosecutor. The Attorney General will know. If I had worked under Alice, Alice will know. I don't really care if the public at large knew because I wasn't running for office. The folks that I needed to pat me on the back could pat me on the back. But if I could get from point A to point B, and if a general counsel sat across from me and says, I don't want this out there, you know what? I was okay with that. And I didn't really look at what the state did. To tell you the truth, I didn't care. I really didn't care. What I cared was, now I used to have 10 cases in my inbox, now I've got 9. I can move this one off to the side, now I can get to the next one.
May I make a
Go
comment
ahead, sure.
follow up on that? I think your question presupposes in discovery that an indictment has been brought, because at least in the federal system, you don't have discovery until that has happened. I don't know, maybe there are states that have pre-indictment discovery. I'm not aware of that. But as a practical matter, a corporation does not want to risk indictment. To be indicted, forget being convicted.
Right.
Being indicted is a horrible, horrible thing to your stock value, to your reputation, to suspension and debarment. And so it's a theoretical question because you never get to that point. Most corporations will try and cut a deal to avoid being indicted, and they will pay all sorts of money to avoid the criminal charge. So the discovery doesn't become a real issue in those situations.
Okay, this gentleman next.
Thank you. First, I heard that federal prosecutors don't have experience, don't know what they're doing. Then I heard, well, they've been there too long, they don't have accountability. Then I hear that Senator Leahy says go do something, and the Justice Department jumps. This is like 4.5 hours of a drumhead court-martial of the U.S. Department of Justice. I've been a federal judge for 15 years. I have not had any misconduct by the prosecution. I only wish that we had some people here from the Justice Department now, they do exist, from the EPA now, so that we could get a level playing field. This is shocking.
Let me comment on that, and since I'm one of the accused here, and I want to say this, and also in response to points that both Roscoe and Alice made. Look, like any other organization, there is dishonesty in the Department of Justice. We know it. We've seen it in the last 2 weeks. Give me a break. But that's not to condemn all. I think the issue really under debate here is, even assuming, and I do assume that most 90-some% of prosecutors are perfectly honest and conscientious, the question is the job they're doing worth doing? That's the issue that I think is worth thinking about, and are they the right people to do it? And I think that's an even more important question.
Can I just comment on because I made a comment about the lack of experience that I had, and I don't think I ever engaged in misconduct, but clearly I think I'd be a better prosecutor now at my advanced stage than I was at my diminished stage. And one of the things that prosecutors are doing now is not just deciding what cases to bring, but in the resolution of the cases saying, I want you to fire the CEO, I want you to change your business plan, I want you to sell that division, I want you to change your board of directors. Right. And I don't think that they know that much. I don't know whether Spitzer requiring Greenberg's firing at AIG did or did not in some way cause this problem. Greenberg says if I were there, it wouldn't have happened. But I don't know. But you do have now federal prosecutors who by the way, a lot of my, some of my best friends are federal prosecutors. And I don't know any dishonest ones. But they are vigorous advocates, which they should be, in protecting the public interest as they see it. The law allows them to do that. The law continues expanding. And there's a philosophical, not a personal issue here, a philosophical issue, it seems to me, as to what is the proper role of the criminal law with regard to corporate conduct. That, to me, is the issue. It's not a personal attack against assistant U.S. attorneys. And while they can be vigorous, if you represent a corporation, either as an inside counsel or as an outside counsel, If you engage in vigorous advocacy to assert and protect the rights of your corporate client, you risk having that held against you under the guidelines and in the prosecutorial decisions because you are not fully cooperating. That's a structural policy issue that we're trying to address here. And I think it's an important issue.
Can we take one more question? Let's take one more, just this gentleman.
Well,
No?
one more.
Okay, sorry.
Actually, I have a
He's the boss. I can't.
actually I have a comment. I've been listening all day at the presentation here, the overcriminalization of corporate conduct. I've been a federal prosecutor for about 17 years, a federal judge for about 16 years, prosecuted many white-collar cases, sentenced many white-collar defendants, and it's just my humble opinion that this whole subject is overblown. Do not believe that corporations are being over-victimized, over-criminalized. I think it's a preemptive strike to avoid accountability. That's my view of this whole matter.
Thank you.
And we
Thank
do,
you all.